Let's dive right into this explainer on the foundational architecture of our legal system. We're going to build a mental map of exactly how the state's power is structured and how it's regulated.
To put it simply, constitutional law creates the fundamental skeleton of state power, and understanding it is the absolute key to knowing how your rights are protected against the government.
Here is our roadmap for today. We'll be doing a step-by-step academic zoom-in. 1. Public versus private law. 2. Constitutional law as public law. 3. Constitutional versus administrative law. 4. Applying the dispute test. 5. Landmark cases. And 6. The rule of law and a quick recap.
Section 1. Public versus private law. Think about signing a lease with a landlord, or maybe buying a used car from a neighbor. If things go south and a disagreement pops up, you'd head to an ordinary civil court to sort it out, right? Well, because this is a dispute between private parties acting as legal equals, it falls under the precise legal term, private law, or historically, jus privatum. This is the domain that governs everyday equal relationships. Think contracts, torts, property, and family law.
But what happens when the rules involve the government? Say, the state charges someone with a crime, or two different government departments get into a turf war. Suddenly, we aren't dealing with legal equals anymore. The precise term here is public law, or jus publicum, a distinction actually rooted in the ancient Roman jurist Ulpian. It governs relationships involving the state. That could be the state versus an individual, or the state's own organs against each other. This whole family includes constitutional, administrative, and criminal law.
Section 2. Constitutional law as public law. So, why does constitutional law sit at the very top of the public law family? Well, unlike administrative law, which really just regulates day-to-day actions, constitutional law creates the entire massive framework that every other branch operates inside of. It's public for two main reasons. First, it's subject matter. It deals with huge concepts: sovereignty, government structure, the distribution of power, and fundamental rights. Second, the parties. It is inherently state versus citizen, or organ versus organ. It is never just citizen versus citizen.
Crucially, this domain offers some very special constitutional remedies. Imagine someone is unlawfully detained by the police. That person can go straight to a high court and demand that the state legally justify the detention. This specific demand is called a writ of habeas corpus. There's a whole toolkit of these special constitutional remedies, known as the writs, which, for example, in India are found under Articles 32 and 226. The rule to remember? Because a private contract dispute between you and your neighbor would literally never invoke these special remedies, this scenario is strictly a matter of public law.
Section 3. Constitutional versus administrative law. Now, things get a bit tricky when we try to figure out exactly where constitutional law ends and administrative law begins. Scholars actually debate this heavily. Let's walk through it. First up, Sir Ivor Jennings. He argued there isn't really a logical distinction between the two, it's just about convenience. To him, constitutional law looks at the organization of the state, while administrative law deals with organization and functions, basically a specialist offshoot. Then you have F.J. Porton and the traditional view, arguing constitutional law lays down the broad structure and powers, while administrative handles the detailed, granular machinery, like licensing or tribunals. And finally, Maitland gives us this brilliant metaphor. Constitutional law is the state skeleton, while administrative law is its detailed daily operation.
So how do we tell them apart in the real world? Here is a super practical, plain language test you can always use. If you're looking at a legal question and it asks, can Parliament do this at all? You're dealing with constitutional law. But if the question asks, did this specific officer exercise a power Parliament already gave them correctly, then you're in administrative law. It's literally the difference between drawing the boundaries and just operating the machinery within them.
Section 4. Applying the dispute test. Let's see this in action. Let's classify 3 different disputes. First, imagine a breach of a shipbuilding contract between 2 companies. The rule tells us that since this is a dispute between legal equals, probably governed by something like a contract act, it lands firmly in private law. Second scenario. A port officer's licensing order gets challenged because they allegedly overstepped their statutory power. Well, since this tests whether an officer exercised their delegated machinery correctly, it lands in administrative law. Finally, imagine a constitutional amendment is challenged on the grounds that it destroys judicial review. This tests the validity of the fundamental framework itself. It's asking, can this state do this at all? Therefore, it lands squarely in constitutional law.
Section 5. Landmark cases. Let's look at how courts actually handle this.
We're going to treat these cases with strict anatomical rigor, starting with a massive one, Keshavananda Bharati v. State of Kerala in 1973. The facts: Parliament exercised its power to amend the Constitution. The issue before the court: is Parliament's amending power absolutely unlimited? The holding: no. The court ruled that the validity of Parliament's amending power must be tested against the basic structure of the Constitution itself. The importance of this cannot be overstated. This is a perfect example of constitutional law operating at its absolute highest level, literally policing the very boundaries of the state's supreme legislative power.
Our next case study highlights a major fundamental shift in the law. Back in 1950, in a case called A.K. Gopalan, the courts took a really narrow approach to a citizen's deprivation of liberty. They basically said, as long as there is any procedure passed into law, that's enough. But then, look at the facts of Maneka Gandhi v. Union of India in 1978. Again, a deprivation of personal liberty under Article 21. The issue: does procedure established by law truly just mean any enacted procedure? The holding: the Supreme Court officially overturned Gopalan. They ruled that the procedure must actually be fair, just, and reasonable, not just a legislative rubber stamp. Why does this matter? Because it's the textbook illustration of public law stepping in to directly police the relationship between the state and the individual, ensuring human rights are actually protected.
Section 6, Rule of Law and Recap. Time to talk about the underlying theory.
Imagine a high-ranking government official gets caught speeding, and they end up having to pay the exact same fine as a local college student. The plain meaning here is simple: no one is above the law. The precise term for this is Dicey's Rule of Law. Formulated by the scholar A.V. Dicey, this vital doctrine requires the absolute supremacy of law over arbitrary power and strict equality before the law for everyone, completely regardless of their status or title. Now, Dicey's original formulation was very specific to the United Kingdom. It represents a model where individual rights simply flow from ordinary law and are enforced by ordinary courts, without needing some grand, abstract written declaration. You can contrast that with the model used by India and the United States. In those systems, individual rights flow directly from a supreme, written constitutional text that permanently stands above ordinary everyday legislation.
All right, let's lock in everything we've covered today in the exact order we learned it to solidify that mental map. First, we divided law into jus privatum, the law of equals, and jus publicum, the law of the state, a distinction tracing back to Oppian. Second, we separated constitutional from administrative law, the skeleton versus the detailed machinery, exploring the perspectives of Jennings, Port, and Maitland. Third, we looked at the basic structure limitation, observing constitutional law operating at its highest level in case of Ananda Bharati. Fourth, we examined the requirement for a fair and just procedure, showing public law policing the state in Maneka Gandhi, which famously overturned A.K. Gopalan. And finally, we grounded the whole system in the rule of law, supremacy and equality as formulated by A.V. Dicey. So if constitutional law forms the skeleton of state power, and administrative law is its daily movement, what happens to the rights of the citizen when the bones themselves begin to bend? Thank you so much for your time and focus today. I hope this framework serves you really well as you continue your legal education and leaves you eager to dig even deeper into the mechanics of state power.